Fabulous.
Yeah.
Right, well, thank you very much for talking to me
Oh,
today.
sure, of course.
So I'll dive straight in with the first question. What do you see as the most critical practical friction point for US companies navigating the EU's approach to copyright originality compared to the US modicum of creativity standard?
So, I mean, that's an interesting question because to a certain extent, the EU considers original certain types of work that the US actually wouldn't consider original. So, and in the US, you have what we call thin copyrights, where the originality relates to something that there is one would not necessarily think they are completely creative. I think that because most copyright law it's court interpreted in either case, um, you're really looking to the court's decisions, and so I'm not certain that there is really such a great friction point because I do think that there are situations where let's say a German company will come into the US and they won't be able to register their work as a copyright. But that may also be the case in a country or multiple countries in the EU.
Yeah.
And conversely, a US company may find that they are able to protect a work in a European country,
Yes.
or through and they aren't able to in the US. So I don't look at it as necessarily a friction point. I look at it as sort of an opportunity to sort of carve out for your client what their rights will be.
Absolutely. Oh, that's cool. I didn't realise that. So as the EU IPO expands its footprint via the Knowledge Centre, how will this centralised hub impact US practitioners managing global IP portfolios?
So I actually really love the Knowledge Center. I think a lot of US practitioners look to third-party vendor sites in terms of trying to find out information on IP in the EU. I actually use the Knowledge Center and think of it as a real gift. So the idea that there will be, that it will be more robust is very helpful, especially for copyrights, because, that's sort of been a blind spot. And also not every European country has a register of copyright. So, but at least this way, it should be easier to either look to see what, competitors have registered, or look to see where a client may want to have a copyright registration, even though they may otherwise not pursue that.
Yeah. So quite handy. Fabulous. How do recent shifts in US copyright jurisprudence, particularly around transformative use, widen or narrow the regulatory gap between the US and the EU?
So that's another really interesting question, because so at a certain point in time, as a US practitioner, in my own jaded view, and not just my jaded view, there was a question of, well, are you really calling a derivative work a transformative use? Like, so where is the line? And there had been some case law that seemed sort of unfairly characterizing certain works as transformative. In the Supreme Court in the Warhol case actually pointed out that you don't want the concept of transformative fair use is very important. It's important to be able to to create different types of works and different vehicles, for research and other things. But at least, so the Supreme Court did, sort of pull it back and say, well, you don't want transformative fair use to swallow rights. And we're seeing that now in the AI cases, really. So we're seeing that even though there haven't been any decisions on the merits of a case, we're seeing that in the earlier stages of the case in motion practice, where courts are looking at the market, whether you're approaching a competitive market, and that is really, in my view, what the EU has been, that's their approach.
Right.
So in that sense, it's the jurisprudence is actually almost harmonizing itself with the EU approach, which is actually a very practical approach, because otherwise, how do you distinguish between something that is a derivative work that the copyright owner has versus something that is transformative, that is in another area that a copyright owner wouldn't necessarily see its business going into.
Right. Okay, awesome. So, I mean, you mentioned how much you like Knowledge Hub, Knowledge Center already. Do you reckon the centralized data from there will help alleviate the enforcement burden that currently falls quite heavily on content owners in the US system?
Yeah, I'm not sure that it's going to help enforcement. I mean, it certainly will help. Um, it will help see the landscape of what claimed rights there are. I don't, usually any copyright owner, if they're going to enforce, they're going into court. So looking at what is on a register isn't necessarily going to help them. But it's helpful to be able to see if somebody else has a claim of rights and try to deal with it in a particularly a different way.
Yeah.
The more information you have at the ready is better. It's not clear to me also how deep that will be, whether it'll just be registrations or whether you'll be able to see deposits, and more information to sort of back up a claim of rights.
Right. Yeah, absolutely. So, how do you contrast the US Copyright Office's strict human authorship guidance on AI? I mean, there was a really cool discussion about this yesterday. Generated content with the emerging legal frameworks being debated across Europe. Obviously, Europe's a little bit divided. I know the UK has a different set of rules.
Yeah.
Yeah.
It's, it's sort of hard to know where this is going to go, actually, because the human authorship requirement, I mean, I think it's I do believe the EU has built into their originality and creativity requirement is human authorship implicitly. So I do think that is how that's looked upon through AI. I think is different because, there might be a point in time. The point in time is not now, where the U.S. will say, okay, if you have 35 prompts and the prompts are really directing something that is that is akin to creativity and human authorship, which actually I think goes back to this the Oscar Wilde photograph case, where it's sort of like, well, here photography is mechanical. That was the argument. It's like, well, no, it's not mechanical. You have the placement of the people. This isn't any different from an etching, which is protected. This isn't any different from a map, which is protected. And so I don't know, at some point in time will the Copyright Office revisit that and say that prompts just unilaterally are not, are mechanical and, void any type of creativity and any type of protection. Because I think having that, from someone just saying, I'm just, putting something in and I should have this, versus someone who has actually used the prompt in a guided way to actually create something that's a visual image that they've wanted to create, isn't that different from, although that's, we're not there yet. So I think in a sense, the EU, this is a very long-winded response, they're not looking at it so, they're mechanically. And so I think there's greater flexibility there because you can't because the registration system is required for U.S. entities, that's going to affect enforcement of someone who legitimately has created a work through AI. I mean, I think the tension here is AI bad altogether, or is AI a tool that can be used not to replace, an author or creative work, but to really almost like a pencil in some way, And what is that line?
Yeah.
And we haven't gotten there. The problem is with the registration system is that it just cuts off that analysis because, at this point you can't get a registration for something, that is wholly created through prompts.
Right. Yeah. I wonder whether even it's the sort of artificial intelligence, the idea that it is learning from everything that it's being told to do, which is making people anxious about, or when maybe is there going to be a day where it can prompt itself, in which case then it's a whole other thing. But the thing that's always given me comfort in terms of AI is that without the human imagination, it can't do anything.
Right.
So it is just like a pencil or a pen. It won't just pick itself up and start drawing, because why would it?
Right. And there has to be some direction. I mean, I think that the difference is, are you just sort of hitting a bunch of keys and accepting what's there, and is the acceptance of what there creative work, or are you actually shaping it in a greater way and using the prompts in a way to create something as you would a collage or anything else, where you're interpreting or picking up something else that's another work.
Yes.
So I mean, to sort of the school that's like it's all bad or all good is those aren't the right approaches. And I think that because of the registration system at this point, we have a very bright line because no one knows really how to change that.
Yeah.
And because you have that line and you also have the requirement of going into court with the registration, you're going to have that issue. And the courts won't be able to make that determination at this point for enforcement purposes, of a work that is AI in part created. I mean, so I think that there is a problem there. There is a big gap there. And in the EU, I don't think there has been, even though they've, I think, thought it through on the back end, I don't think there's been any case law. So it's not clear what's going to happen at this point.
Right.
Yeah.
There needs to be some examples, etc.
Yeah,
absolutely. So what's the single biggest piece of advice that you're giving US rights holders this year to future-proof their creative assets against these diverging transatlantic copyright rules?
So, I mean, I really believe when my clients go into another country, they should really shore up all their IP. And if their IP includes, copyrighted works, and oftentimes that really requires doing a due diligence of what is in the deal, because these are essentially issues where you're going into another country, because you have a working relationship there, because you are now located there. What do you own? And oftentimes the hardest thing to decide what you own has to do with the copyrights. The trademarks are generally vetted. You know what patents you have in when you're going to rely on trade secrets. But oftentimes what I have seen, depending on the type of company, and some companies are extremely copyright focused. But for companies that aren't, but do have that, to really do a due diligence and determine what you own. And the U.S. registration process is not complicated, and try to get that ironed out first so that you have, essentially a schedule of what you own. And I think that's helpful. You have your own knowledge center. Because otherwise, and to the extent that that's possible, I think that's what I would advise clients who really are intending to go into Europe and have not. Once you have that, then you at least have a framework of what to work with if you have enforcement issues.
Absolutely. Well, thank you very much for talking to me today.
Thank you for having me.